What's going on YouTube? Listen up, young elder gang. This is Shalonda Williams, one of Big Mama's daughters, the lawyer and real estate agent at You with Another Banger. Please make sure you like, subscribe, and share this video, fam. I hope this video get at least 100,000 likes. In the following video, you will find history, definitions, scripture information, and best of all, what we Americans have been deprived of from the beginning, the truth. Keep in mind, this content used in this video is intended for educational and informational purposes only. We will give you the total truth as we best understand it today. Be sure to hit that like button, young elder gang. Hit that subscribe button if you're new to the channel. Hit that bell and don't forget to check back with us every day for new content. All right, let's get started. You need to hear this if you're a finance enthusiast. Can you really trust banks as fiduciary agents? Banks can act as fiduciary agents, meaning they manage and care for property on behalf of others. This includes providing services that act in the best interests of their clients. So, what do fiduciary agents do? They manage property, pay bills, and give financial advice, all while acting honestly and loyally. Banks offer services like trust administration, executor duties, and financial advisory. But they need approval from the Office of the Comptroller of the Currency and must follow strict policies. In short, banks have to play by the rules and put your interests first. So yes, banks can be trusted as fiduciary agents, but always do your homework. Yes, banks can act as fiduciary agents, managing and caring for property for others. They do this by providing services that act in the best interests of their clients. What does a fiduciary agent do? Manage property. A fiduciary agent is legally required to act in the best interests of their client. This includes managing their property, paying bills, and providing financial advice. Act honestly and loyally. A fiduciary agent must act in a trustworthy, honest, and loyal manner. What services do banks offer as fiduciary agents? Trust administration. Banks can act as trustees for clients. Executor duties. Banks can help close estates by acting as executors. Financial advisory services. Banks can provide financial advice to clients. What are the requirements for banks to act as fiduciary agents? Banks must obtain prior approval from the Office of the Comptroller of the Currency, OCC.gov. Banks must adopt and follow written policies and procedures that comply with applicable law. Banks must be able to identify, measure, monitor, and control the risks of their fiduciary activities. A beneficial aspect of a trust refers to the advantage that the designated beneficiaries receive from the trust, meaning they are the individuals who will benefit from the assets held within the trust, allowing for controlled distribution of wealth according to the grantor's wishes, often avoiding probate court and providing privacy regarding asset ownership. Key benefits of a trust for beneficiaries. Controlled distribution. The grantor can specify exactly how and when the beneficiaries will receive assets, which can be particularly useful for managing inheritances for minors or individuals with special needs. Asset protection. Depending on the type of trust, assets can be shielded from creditors or lawsuits, protecting the beneficiary's inheritance. Privacy. Unlike a will, which becomes public record, a trust can keep details about the assets and beneficiaries confidential. Avoidance of probate. By placing assets in a trust during one's lifetime, the beneficiaries can avoid the lengthy probate process after the grantor's death. Some of the ways trusts might benefit you include protecting and preserving your assets, customizing and controlling how your wealth is distributed, minimizing federal or state taxes, addressing family dynamics, for example, divorce or blended families. A trust is a legal arrangement that involves a grantor, trustee, and beneficiary. The grantor creates the trust, the trustee manages the trust, and the beneficiary receives the benefits. Grantor, the person who creates the trust and usually owns the assets that are put into the trust, also known as the truster, settler, or creator. Trustee, the person who is legally responsible for managing the trust assets. The trustee must act in the best interests of the beneficiary's beneficiary, the person or group of people who receive the benefits from the trust. The primary beneficiary is the first person to receive the assets. Trust agreement, a written document that outlines the rules and instructions for the trust. The grantor works with an attorney to create the trust agreement. Trust purpose. A trust can provide legal protection for assets and ensure they are distributed according to the grantor's wishes. Declare the value means to state the monetary worth of a shipment when sending a package through a carrier, essentially informing the shipping company how much the items inside are valued in case of loss or damage during transit, which determines the maximum amount they will be liable to pay for compensation. This value is usually based on the purchase price of the goods. Key points about declare the value. Purpose. It is used to set a limit on the carrier's responsibility for a package if it gets lost or damaged. Importance for customs. When shipping internationally, the declared value is also used for customs purposes to calculate import duties based on the stated value of the goods. Accuracy is key. It's important to declare the accurate value of the items to avoid issues with customs or potential underinsurance claims. Declared value is the value placed on imported goods by the importer. The value of the goods is declared for clearance at the port of entry, and it is used to determine the amount of duty to be paid on the imported goods. 2. Declared value is the amount a shipper stated to the carrier that his shipment is worth. A public entity is a government agency, office, or department that provides services to the public. Public entities can also be state or local governments themselves. A public entity refers to an organization owned and operated by the government, like a public school or government agency, while a private entity is a business or organization owned by individuals or private investors, not affiliated with the government, such as a privately held company. Key differences. Ownership. Public entities are owned by the government, while private entities are owned by individuals or private groups. Funding. Public entities often receive funding from taxes, while private entities generate revenue through selling goods or services to the public. Transparency. Public entities generally have to disclose more financial information due to public oversight, while private entities have more privacy regarding their finances. Stock market access. Public companies can sell shares on a stock exchange, allowing the general public to invest, while private companies do not publicly trade their shares. Examples: public entities, government departments, public schools, public hospitals, public transportation systems; private entities, small businesses, family-owned companies, large corporations that are not publicly traded, nonprofit organizations. Private companies are owned by founders, executive management, and private investors. Public companies are owned by members of the public who purchase company stock, as well as personnel within companies, founders, managers, employees, who possess shares of company stock as a result of the IPO and purchases. Contract law is the legal framework that governs agreements between parties. It establishes rules for creating, interpreting, and enforcing contracts. How does contract law work? Creates obligations. Contracts are legally binding promises between parties to perform in some way. Provides remedies. If a party breaches a contract, the law provides remedies to the harmed party. These remedies can include monetary damages or specific performance. Ensures fairness. Contract law helps ensure fairness and predictability in business dealings and everyday transactions. What types of contracts are there? Homeowners association documents. Covenants such as restrictions on home color or landscape requirements are contractual obligations. Easements. Easements allow another party to use part of your property, such as a utility company running electric lines to your house. Liens. Liens are legal claims to property based on a loan the property owner took out. Copyrights. Copyrights are contractual agreements that protect inventions or concepts you create. How does contract law vary by state? Contract law varies from state to state. Some specific court interpretations of a particular element of the contract may vary between the states. A contract is an agreement that specifies certain legally enforceable rights and obligations pertaining to two or more parties. A contract typically involves consent to transfer of goods, services, money, or promise to transfer any of those at a future date. The activities and intentions of the parties entering into a contract may be referred to as contracting. In the event of a breach of contract, the injured party may seek judicial remedies, such as damages, or equitable remedies, such as specific performance or rescission. A binding agreement between actors in international law is known as a treaty. A declaration of trust is a legal document that states how an asset, like a property, is held on trust for the benefit of one or more beneficiaries, outlining the ownership shares of each party involved and specifying who is considered the true owner, even if they are not the legal title holder. It's often used when multiple people purchase property together to clarify individual ownership percentages and rights to the asset. Key points about a declaration of trust. Purpose: to clarify ownership interests in an asset, particularly when multiple people are involved, and to ensure each party receives their rightful share upon sale or distribution. Key details included the names of the trustee, person holding the asset, beneficiaries, people who benefit from the asset, the proportion of ownership each party holds, and any conditions regarding the management and distribution of the asset. When it's used, when buying a property with someone else, especially if contributions are unequal, to protect the interests of each party. Legal nature: considered a legally binding document requiring proper execution and signing by all involved parties. Principles and doctrines refers to a set of fundamental beliefs or truths within a system, where doctrines are the core, unchanging truths and principles are guidelines or applications derived from those doctrines, providing direction for how to live and make decisions based on those core beliefs, often used in religious contexts to describe the foundational teachings of a faith. Key points to remember. Doctrines are foundational truths. These are the established, unchangeable beliefs that form the basis of a system, like God exists or Jesus Christ is the Son of God. Principles are guidelines based on doctrines. Principles act as practical applications of the doctrines, offering direction on how to behave or make decisions in different situations, like love your neighbor or always be honest. Example: doctrine, the atonement of Jesus Christ, the belief that Jesus sacrificed himself to redeem humanity. Principle: repent and be baptized to receive forgiveness. A guideline based on the doctrine of the atonement. Basically, a doctrine is something taught by the church, while a principle is an essential doctrine upon which other doctrines are based. The United States Code is the official codification of the general and permanent federal statutes of the United States. It contains 53 titles, which are organized into numbered sections. The U.S. Code is published by the U.S. House of Representatives Office of the Law Revision Council. A contract is a legally binding agreement between two or more parties that outlines specific obligations each party must fulfill, while a trust is a legal arrangement where one person, the trustee, holds property on behalf of another, the beneficiary, with a fiduciary duty to manage the assets according to the terms of the trust agreement. Essentially, a contract focuses on exchange of promises and defined actions, while a trust focuses on managing assets for the benefit of another party with a higher standard of care and loyalty. Key differences. Relationship between parties. In a contract, parties are typically equal and have reciprocal obligations, whereas in a trust, there is a clear hierarchy with the trustee holding legal title to the assets for the benefit of the beneficiary. Purpose. Contracts are used to formalize agreements and ensure specific actions are taken, while trusts are primarily used to manage assets and distribute them according to the settler's wishes, often for estate planning purposes. Fiduciary duty. A trustee in a trust has a high fiduciary duty to act in the best interest of the beneficiary, which is not necessarily present in a standard contract. Legal entity. A contract does not create a separate legal entity, while a trust can be considered a separate legal entity depending on jurisdiction. Example: contract. A contract to purchase a house where the buyer agrees to pay a certain price and the seller agrees to transfer ownership of the property. Trust. Setting up a trust to manage your assets after your death, where a designated trustee would distribute your property to your beneficiaries according to your wishes. A properly drafted trust is a legal document that clearly outlines the intentions of the grantor, creator of the trust, specifying who will receive assets, how they will be managed by the trustee, and under what conditions, ensuring the trust effectively distributes assets according to the grantor's wishes, while adhering to all relevant legal requirements in their jurisdiction. Essentially, it is a well-structured trust with no ambiguities that can be easily interpreted by the courts. Key elements of a properly drafted trust. Clear identification of the grantor, trustee, and beneficiaries. The document must explicitly state who is creating the trust, who will manage the assets, trustee, and who will receive the benefits, beneficiaries. Detailed description of the trust assets. The trust should clearly list all assets being transferred into the trust, including real estate, financial accounts, personal property, etc. Define distribution guidelines. The document should specify how and when the trust assets will be distributed to the beneficiaries, including any conditions or milestones that need to be met. Provisions for managing the trust. Clear instructions regarding how the trustee should manage the trust assets, including investment strategies and responsibilities. Contingency planning. Addressing potential scenarios like disability or incapacity of the grantor, including provisions for successor trustees. Why is proper drafting important? Avoids legal disputes. A well-drafted trust minimizes the chances of family conflicts or legal challenges regarding the distribution of assets after the grantor's death. Protects beneficiaries. Properly defined conditions and distribution guidelines can ensure that assets are distributed as intended, protecting beneficiaries from mismanagement or premature access. Tax efficiency. A well-structured trust can help minimize estate taxes and maximize tax benefits for beneficiaries. Who should draft a trust? Due to the complex legal nature of trusts, it is highly recommended to consult with an experienced estate planning attorney to ensure your trust is drafted correctly and meets your specific needs. A private trust benefits a specific group of people, while a public trust benefits the public or a charitable organization. Public trusts are subject to more scrutiny and transparency than private trusts. Beneficiaries. Private trust benefits a specific group of individuals, such as family members. Public trust benefits the general public or a charitable organization. Examples: private trust. A family may establish a private trust company to manage their assets across generations. Public trust. The public trust doctrine is used to maintain lakes and streams for drinking water and recreational activities. A public trust, also known as a charitable trust, is an express trust created for a charitable purpose. If an express trust is not a charitable trust, it is deemed to be a private trust. A private trust is an express trust created to benefit a few persons. A breach of trust is when someone breaks the rules of a trust or takes advantage of property that was given to them. This can include a trustee breaking the terms of the trust or a person stealing or misusing property that was entrusted to them. Examples: a trustee invests trust assets in an unauthorized way. A trustee distributes assets to a beneficiary who is not entitled to them. A trustee takes advantage of business opportunities that belong to the trust. A trustee borrows money from the trust for their own personal use. A valet drives a car around the city after being paid to park it. A child uses money given to buy milk and eggs to buy candy instead. Consequences: beneficiaries may be able to sue for monetary damages or equitable remedies. The trustee may be liable to the beneficiaries for any losses caused by the breach. What constitutes a breach of trust? A breach of trust can be intentional or unintentional, and it can be caused by negligence. A breach of trust can be a failure to perform a duty or a failure to meet a standard of care. Face value refers to the nominal or printed value of a security, like a stock or bond, as assigned by the issuer, usually a fixed amount with little relation to its market price, while equitable value represents the estimated fair market value of an asset between two knowledgeable and willing parties, taking into account the respective interests of each party, essentially reflecting a more accurate market-based valuation than face value. Key differences. Origin. Face value is a predetermined value set by the issuer, while equitable value is determined based on market conditions and negotiations between parties. Relevance to market price. Face value often has little relevance to the current market price of a security, whereas equitable value aims to reflect the true market value. Application. Face value is primarily used for accounting purposes, while equitable value is used in situations where a fair and accurate valuation of an asset is needed, like in mergers and acquisitions. Example: face value. A company might issue a stock with a face value of $1 per share, but its actual market price could be $10 per share. Equitable value. If a company is being acquired, the equitable value would be the estimated fair price that a willing buyer would pay to a willing seller, considering factors like the company's earnings, assets, and market conditions. A subcontractor is a person or business which undertakes to perform part or all of the obligations of another's contract. And a subcontract is a contract which assigns part of an existing contract to a subcontractor. A general contractor, prime contractor, or main contractor may hire subcontractors to perform specific tasks as part of an overall project to reduce costs or to mitigate project risks. In employing subcontractors, the general contractor hopes to receive the same or better service than the general contractor could have provided by itself at lower overall risk. An authority to convert typically refers to a legal or administrative body within a specific context, usually related to religious conversion, that has the power to officially recognize and validate someone's conversion to a new faith, often requiring them to undergo a process of study and evaluation to ensure the conversion is legitimate and voluntary. Most notably used in the context of Jewish conversion, where a conversion authority oversees the process under Jewish law. Halakha. Key points about the authority to convert. Function. It determines if someone has met the necessary requirements to be considered officially converted to a new faith. Religious context. This term is most commonly used in Judaism, where the conversion process is strictly regulated and overseen by a designated authority. Process. Individuals seeking conversion usually undergo a period of study, learning about the new faith's practices and beliefs, and may be required to appear before a conversion court or panel to demonstrate their commitment. Double-entry bookkeeping, also known as double-entry accounting, is a method of bookkeeping that relies on a two-sided accounting entry to maintain financial information. Every entry to an account requires a corresponding and opposite entry to a different account. The double-entry system has two equal and corresponding sides, known as debit and credit. This is based on the fundamental accounting principle that for every debit, there must be an equal and opposite credit. A transaction in double-entry bookkeeping always affects at least two accounts, always includes at least one debit and one credit, and always has total debits and total credits that are equal. The purpose of double-entry bookkeeping is to allow the detection of financial errors and fraud. For example, if a business takes out a bank loan for $10,000, recording the transaction in the bank's books would require a debit of $10,000 to an asset account called loan receivable, as well as a credit of $10,000 to an asset account called cash. For the borrowing business, the entries would be a $10,000 debit to cash and a credit of $10,000 in a liability account, loan payable. For both entities, total equity, defined as assets minus liabilities, has not changed. Thanks for watching. Hit the like button if you found this helpful.